another update on some legislation designed to protect children. A federal court has blocked Texas from enforcing part of a state law to protect children from sexually explicit material in schools, while a challenge to the measure is litigated. On Wednesday, a 3-judge panel of the U.S. Fifth Circuit Court of Appeals upheld a lower court's preliminary injunction against a key section of House Bill 900 that requires vendors to rate books sold to Texas schools based on their sexual content. HB 900, also known as the Reader Act, passed last year as a Republican priority and then was immediately, of course, challenged in the courts. The appellate court said that the plaintiffs, which is a coalition of book vendors and publishers, are likely to succeed on the merits of their claim that the book rating regulation violates their First Amendment rights. Plaintiffs called the regulation textbook-compelled speech. The court's opinion, interestingly, was written by Circuit Judge Don Willett, a former Texas Supreme Court justice. The Fifth Circuit panel concluded, quote, "The ratings Reader requires are neither factual nor uncontroversial. The statute requires vendors to undertake contextual analyses, weighing and balancing many factors to determine a rating for each book. Balancing a myriad of factors that depend on community standards is anything but the mere disclosure of factual information, and it is already proven controversial." So what does this mean? Well, the appellate court's ruling stops Texas from enforcing the vendor rating requirement while the state and plaintiffs continue to litigate the merits of the case. The Reader Act also requires Texas schools to adopt standards prohibiting sexually explicit materials in campus and classroom libraries. That part of the law was not enjoined, and the state approved the mandatory school library standards back in December.